the matter of Harama versus Harama, case number 22-11329-DO. Present in the virtual courtroom, we have both parties as well as their attorneys. Mr. Wrigley on behalf of the plaintiff, Ms. Harama, Ms. Lesnick on behalf of the defendant, Mr. Harama, and we are here on the defendant's motion to terminate spousal support. Ms. Lesnick, I have read your motion.
Thank you. Yes, the motion speaks for itself, Your Honor. The parties did enter into an agreement which resulted in the judgment of divorce being entered, as well as a uniform spousal support order that was entered contemporaneously with the judgment of divorce. Per that spousal support order, Mr. Harama is required to pay $1,000 a month effective September 1st of 2024. In November 2024, he lost his employment. That was a significant reduction of his income, and which would equate to a change of circumstances justifying an evidentiary hearing to determine whether or not spousal support will be terminated or modified. We're asking for an evidentiary hearing to determine if the court would terminate or modify spousal support based on the fact.
Mr. Wrigley, I've read your response as well.
Thank you, Your Honor. Benamar Wrigley Jr. appearing on behalf of plaintiff Mary Harama. Couple of additions to that particular reply. I would point out, number one is that, again, lost his employment. There is no indication of any kind of documentation that he was fired. Was it a severance? So we really don't know. Obviously, information all have to come through discovery from in on time. So we really don't know under paragraph 8. Then it lists also the monthly income. Interestingly, it's the word monthly, not his total income of Social Security. And as you saw reading my reply, somehow he missed about $1,000, $800, I'd say, in Social Security based on the March 2024 letter that shows he really is making $2,700. Obviously, if there has been if Mr. Harama is not employed, if he's not picking up jobs for cash. If you remember, this is the case where, when I came into it, we found $142,000.
Your Honor, I'm going to object to that. That is neither relevant or appropriate for this motion.
Well, sure it is. It's credibility.
Well, I think, let me just cut to the chase. I think we've got a factual dispute here. I think we do need to set an evidentiary hearing. And I do think some discovery needs to be permitted, if nothing else, in the hopes of coming to some sort of an agreement. Ms. Van Oller, do we have a date for that evidentiary hearing? I would say put it out at least 6 weeks or more.
All right, just 1 second. So we'd be looking at the end of February. More would be the beginning of March. We could do March 3rd from 9 a.m. to noon. Are we doing a full half or a half day for this, Judge?
I think that would probably be appropriate.
Okay.
I'm actually in front of Judge Gottlieb that day, Your Honor.
Okay, we'll find another day.
Oh, I thought
I
maybe
can
you were
do
going
the
to kick it.
afternoon. If you want to do the afternoon, Your Honor, I'm available for the afternoon.
Yes, we have March 3rd, 2 to 5 available via Zoom.
I'll be actually in person, so I have in person with Judge Gottlieb. So if the court wants to do in person, or I can do via Zoom.
I'm trying to do as much as I can via Zoom, so unless there's a really good reason to do it in person, I think Zoom would be fine.
So 2 to 5.
Yes.
Does that work for you, Mr. Wrigley?
Yeah, it does, assuming we get obviously cooperation from all the people, and we need to get it from discovery. If there's a problem, I will let you know right away. I'll let Jennifer know right away first. But okay. I don't expect any problems with Jennifer. We'll get the material out to her immediately. In on time, I've already drafted. I just haven't had it typed. It'll get typed over the weekend and get out to them. We can we get depositions in that period of time. So March 3rd, 2 to 5 p.m.
All right. We will see you then.
Okay.
Thank you.
Thank you.
Thank you. We're adjourned. Good morning. This is the matter of Linish versus Cali. Present in the virtual courtroom, we have both parties as well as their respective attorneys. We're here on the defendant's motion for counseling. We're here on an objection, the plaintiff's objection to the ex parte order that was entered in this matter. I believe that the defendant's motion for counseling has been at least somewhat resolved for the moment. I think what we'll just say is it's adjourned, pending counsel taking some action that we discussed in chambers. And then we'll move on to the objection to the ex parte order that was entered in this matter. And Mr. Haslam and Ms. Drake, as I've already indicated in chambers, I've read everything that you've submitted, so you don't need to rehash all of it. Just hit the high points. Mr. Haslam.
Your Honor, just real briefly, within our motion, we also had a request for relief from the order requiring mediation before any motion be filed. Did you want to address that after the objection?
Yes, I think that's a separate issue.
Thank you.
All right, Mr. Haslam.
Thank you, Your Honor. And this is there's been a lot of paper submitted on this case. We first filed a response and an objection to the ex parte order. We then filed, as the court knows, a motion for reconsideration very shortly after entry of that order. That I don't believe has been ruled upon yet. And then we, knowing and understanding the court's schedule, we then filed a supplemental objection with the notice of hearing, for today. And it is our considered opinion that this ex parte order was based, we believe, on the defendants affirmatively misleading the court, posing and posturing as if there had been any a scintilla of evidence that there was any inappropriate activity. My client, his wife, his stepchildren, or himself, no probable cause was found to move forward in any of these. The court has those two CPS reports. But I need to point out for the court and the mid-December report and disposition and dismissal in relation to the latest round of allegations contains some information that we believe should be quite concerning to the court. I'll refer the court to page 15 down under the date 11/29/2004 at 8:41 a.m. And it says, a text was received from Tyler Glass, that again is the defendant's law enforcement officer husband, asking for the status of the case and if CPS had spoken with Kyle Linish because Tony is terrified and does not feel safe to go to his house as she is scheduled to go there that day. I would next then, now in the intervening time, I would refer the court to Exhibit B to our motion for reconsideration, which I believe the court probably has in front of it. That was filed on December 3rd. There is an Our Family Wizard email. Well, I call them emails, call them communications, call them what you will. There is an assertion by the mother, 11/29 at 3:18 p.m. The second line of that communication, we were informed by CPS that it would be recommended to you, Tony, stay with us. And as the court can further see, if you advance to page 19 and read the substantive reportage under December 5, 2024, text received from Mackenzie Cali stating that CPS have told her and her husband that CPS would suggest Mr. Linish, they left out the preposition to Mr. Linish that Tony should stay with them until the investigation is over. But Mr. Linish's attorney stated that CPS have never said anything like that. Ms. Cali asked if CPS have not told Kyle that. Then there is more texting, and you can see that the supervisor stated CPS cannot get involved in court matters or visitation, so CPS will not be involved in any court matters. Ms. College, that's their misspelling, not mine. Ms. College texted back saying that CPS had told her and her husband that CPS would advise, suggest Mr. Linish to let Tony stay with her until the investigation ends, and asked what the safety plan is. And again, text sent back to Ms. Colley advising that CPS cannot get involved in court and visitation matters, and asked her to speak with friend of the court regarding issues, which I know, as we all know, is a bit of a misnomer. But what you have here, Your Honor, is more actions by the defendant and her husband to create a narrative. It's like they're trying to create that they were told that the recommendation from CPS is, wow, we think these charges or these allegations are so serious that this child should be held. That was all their idea. And the fact that we get a CPS report that where they're trying as hard as they can, apparently, to run the false narrative that a CPS worker supported their scheme. I find repugnant. And again, she even tried to run that on Mr. Linish on the 29th. Well, the fact is, it's not true. We also supplied the court with an email communication from the assigned worker verifying, and that's in front of the court, verifying that they never said any such thing. We have a situation here, Your Honor, where it is apparent that pressure is being brought to bear on this child in her mother's environment. We have a situation where, and this is, I think the court will find this particularly disturbing. Mom has apparently been in close communication with the school social worker.
Mr. Haslam, I'm going to interrupt you. I've read all this in your pleading.
All right, Your Honor, what we're asking for today is my client has an established custodial environment. He has considerable parenting time. He's already missed considerable parenting time. We're asking this court to immediately rescind this ex parte order and reestablish his parenting time beginning today. He's got 18 days of parenting time that need to be made up, and we don't want to be in the backwash of currents and eddies trying to get that scheduled. We think it ought to be scheduled immediately. Because of the holidays, he's only been able to see his daughter twice since mom and stepdad spirited her out of the school, in a situation wherein, I'll tell you what, if I were a child, I would be traumatized by my maternal grandfather assaulting and battering my father in front of me. And there's a PPO against this maternal grandfather, Your Honor, and my stepfather telling my father, "You're only good for the child support. You're a horrible dad," et cetera, et cetera, et cetera. None of this ever should have happened, and it certainly shouldn't have played out in front of this child. My client did nothing. He was passive. He said, "Hey, look, it's my parenting time." That didn't matter to them. They spirited her right out of the building. So this was all a false construct. And again, as we discussed in chambers, we have a child here who probably is under a tremendous amount of stress from I hesitate to call it brainwashing. That's kind of an inarticulate, loosely framed term of art, but the pressure to say things. We've had this play out now with 2 referrals to CPS. It looks like they came from this school social worker. My client, who has joint legal custody, and even if he didn't, as the court knows, there's a statute on that. He's entitled to all information, all school records, et cetera. He tries to get in touch with the school social worker to say, hey, what's going on here? You apparently are seeing my daughter for whatever kinds of sessions where she comes and talks to you. I'd like to talk to you about that. Their response, Your Honor, is make a FOIA request, even after he cited to them and provided to them his documents showing he has joint legal custody, even after he provided to them a citation to the statute that said even if he didn't have joint legal custody, he's entitled to all the school information. What's clear here, Your Honor, is that defendant mother is running a play with the intention of alienating this child from her father. And those are the bases upon which we believe this ex parte order was improperly obtained, needs to be rescinded, and we need to proceed to make up parenting time.
All right, thank you, Ms. Drake.
Thank you, Your Honor. If anyone's creating a narrative, I think that it is plaintiff and his counsel. These facts are not accurate at all. The minor child's first investigation with CPS arose after standard testing and questions that the school runs. My client had nothing to do with it. It raised some red flags. The school social worker, who is with the school, a school social worker, something that's a resource at the school for the students, not someone that my client engaged, reached out to the minor child and reached out to my client because there were concerns and CPS was going to be getting involved. My client has not prevented any communication by the plaintiff here. She has just responded and reached out when Tony was having a very rough day, since Tony had already established a relationship with the social worker at school. Fast forward, after the first investigation where the minor child disclosed inappropriate touching by stepmom and step siblings, the child is expressing that she was injured and terrified because dad picked her up and dropped her. It ended up coming to light at the basketball game where mom attended. There are multiple witnesses of this altercation. The allegations that my client's father attacked the plaintiff or that her husband made these comments is not supported by any evidence. The child made these claims to the police officer, who filed a police report or filed with CPS based on the claim of the child, and also forward the proposed charges to the prosecutor for the alleged assault. My client has been acting as a gatekeeper to protect the minor child. The first ex parte that we filed and withdrew was at the request of CPS. We withdrew it when they were able to establish a meeting with Mr. Lynch. Then this new investigation came to light. As I stated, it escalated, so my client asked that we file an ex parte because of concerns for the mental and physical health of the minor child. She has never engaged in alienating behavior. She has listened to what the child's complaints are and acted as a mother in trying to protect her. She acted on statements that she received from CPS, and I think we can all acknowledge that CPS workers are not perfect, and they say one thing to one party and something to the other, and then they may learn that that's not appropriate and backtrack. I've seen it in many cases. That's what happened here. The CPS worker indicated to my client before speaking with Mr. Linish that we're going to recommend that the child stay with you. Clearly, that was not communicated to him. And now it's being portrayed that my client is some sort of monster trying to rip the plaintiff away from the minor child. She wants a healthy, safe environment for parenting time to occur, which the child has explained to the police and CPS that she feels like things have escalated since she disclosed the uncomfortable touching from the first CPS investigation. The case was unsubstantiated. We acknowledge that. The risk level has increased, probably because this has occurred just a month after. But we agree that counseling needs to get set up here to give the minor child a resource to address her concerns and rebuild her relationship with her father, because there's something going on. We don't know what it is, but there's something going on and the minor child is suffering. I would also note that my client has made every effort for the plaintiff to have parenting time with the minor child over the holiday season. He has not attended any sort of event for the minor child since the filing of this. He has not reached out to the minor child to wish her a Merry Christmas, reached out just to see how she's doing. Just because there's an ex parte making parenting time supervised doesn't mean that he can't reach out and see how she's doing, request phone contact. None of that has occurred. I would also note that after we filed the ex parte is when these alleged assault claims came to light. Contact to my client's husband's employer trying to get him fired, as well as filing a PPO against my client's father, which I believe he has filed an objection to. At the end of the day, the person that we need to be most concerned about is Tony. And I think getting her into counseling to get to the root of this problem is the first step. And we would just ask the court to consider that in making its recommendation. As a side note, I would also note that my client's sister is in from out of the state, and it is technically her weekend. So we would request, if the court is going to order unsupervised parenting time and any sort of makeup time, that it would occur after this weekend. So one, the child can be prepared for parenting time to restart, and two, so she doesn't miss out on the visit from a relative that is from out of state.
All right, thank you.
I do need to respond, Your Honor.
Actually, Mr. Haslam, you guys have taken up quite a bit of time at this point. So, and I've read everything, and I mean, this could go on for a long time, and I'm not going to do that. So, I do believe that the circumstances under which, or the alleged allegations under which the court issued this ex parte, are no longer a concern, at least not as far as irreparable harm. So the court will rescind the ex parte order, and that current parenting time order is back in place. And I will indicate that they should follow their regular schedule, which would be commencing next weekend. And in the meantime, though, I will refer this to the front of the court regarding parenting time, because I really want a deeper dive into what's going on. I'm not going to include it in an order because that can impact insurance at this time, in which case both parties will end up having to pay out of pocket. This child needs counseling. It doesn't matter why she's in the situation she's in or what caused her to be in the situation she's in. She needs to have a safe person that she can talk to. And so I had a conversation with counsel and chambers, and they're going to work very hard to try to make that happen within 7 days, but we are not including it in an order for that reason. Yes, Mr. Haslam.
Question, Your Honor. Is the court reserving on these 18 days of makeup parenting time?
Yes. I think at this point we need to get some more information into really how she's doing and what's going on before we impose that. I'm reserving those.
Very good, Your Honor.
All right.
Would the court like me to prepare an order to this effect?
Yes, please.
I will do.
And I'd be happy to review that to sign it as a stipulated order.
I'm sorry?
I'd be happy to review that if you want to send it to my office so we can submit it as a stipulated order.
I'll send
or
it.
Stipulated as to form and content.
Okay.
I'll send an order with an approval line as to form, since it was a contested motion. And I had asked prior for a stipulation, which was refused. So.
All right. Okay. And then we will move on to the
Your Honor, can I ask one more question?
Sure.
Can we carve out in the parenting time that the minor child will be given access to contact either parent at her discretion during the other parent's parenting time? Because currently my client, the minor child, has not been allowed to contact my client during any of the plaintiff's parenting time.
Your Honor, look, I think that presents a lot of issues. I have certainly been involved in cases in over 34 years where, you end up with dad's doing this, dad's doing that. And it puts the child under a tremendous amount of pressure. I don't mind, and I think that's probably already covered in the prior orders that exist in this case. There can be telephone contact for reasonable times, at reasonable times and for reasonable durations. But to just say, yeah, this 10-year-old is going to walk around with a phone, because we know what's going to happen. It's going to be, what are you doing? What is your dad doing?
All right.
And it will be the side.
Given the context of this case, I'm going to say no at this time.
Thank you.
All right. And then now, can we move on to the mediation issue?
Thank you, Your Honor. We are just asking that there be relief from order. It's become pretty clear that these parties do not get along. They agreed 4 years ago, 5 years ago, that they would get a counselor for the minor child. They haven't been able to agree on that. Things have escalated. I think that it's appropriate that if they have the appropriate proofs of proper cause or change in circumstance, or there is potential irreparable harm, that either party should be able to file a motion. There can be arguments made, and if the court finds that it's reasonable for mediation to occur at that point, or counsel can make an argument for mediation prior to an evidentiary hearing, that would be the appropriate time for the court to order that, not making it mandatory before any motion be filed in this instance, or in this case.
Well, Your Honor, we have, consent orders can only be modified if there was fraud, duress, or mutual mistake. There certainly wasn't any mutual mistake. I think the court has its own understanding of, if there are emergent circumstances with respect to irreparable harm occurring, I guess that is always open to either of these parties. But there's been absolutely no showing that consent term was obtained by fraud, duress, or mutual mistake. We have it, and in fact, it worked against my client a couple of years ago when, if I recall correctly, there was an issue with communication and a vacation. If I remember correctly, the defendant refused to engage in time. We filed a motion. We received back an order from the court that said, look, mediation is mandatory. Your motion is dismissed. I think, if I'm not mistaken, that was in 2021 or 2022. But look, I think the court knows. The court knows, with this court's vast experience, the court knows the metes and bounds of what constitutes an emergency that would result in irreparable harm potentially, and what wouldn't. So I don't see a basis for this relief, and I would respectfully ask the court deny this request.
Well, the court does have to hold both parties to what they've consented to, unless, as Mr. Haslam indicates, there is a very high bar that is met, which is fraud, duress, etc. I'm not hearing that. And any of the other reasons not to do mediation, just because the parties don't get along, is actually a very good reason to try mediation before coming to court and spending the money for that. It's always in the best interest of a child, particularly, to have parents come to an agreement. And oftentimes it does take a third party neutral with extra time that the court doesn't have to work with the parents to come to an agreement. So I'm going to deny the request at this time.
I have one final, I'm sorry to take the court's time. I have one final logistical question, Your Honor. You said you were referring the matter to the friend of the court for a parenting time investigation, report, and recommendation. Is the court preparing its own quadruple referral form like on MASH, or do you want me to include that in the order?
No, we will do the referral.
Okay, thank you.
And I will indicate that the parties are split the fees.
Very good. Thank you, Your Honor. Understood.
All right. Is there anything further?
Not that I can think of at this time.
No, I just want to reiterate that the motion for relief from the order requiring mediation is denied. However, the motion for counseling is adjourned for reasons stated on the record.
Correct.
Okay, and I will prepare that and send that over to you, Mr. Haslam, for review as to form.
Wait, I thought I was preparing the order as we established.
There's two motions. Did you want to prepare both, or do you want to include it all in one?
It seems it seems to me, in the interest of efficiency and judicial economy, one right? One order arising out of the matters that were litigated before the court today makes more sense.
All
I don't
right.
know
I'm
if
fine
the
with
court
that.
agrees with
I have
Okay.
no issue.
All right,
All right.
thank you.
That's fine. Thank you.
All
All
right.
right. Have a
Thank
great
you. We're
weekend, Your Honor.
adjourned. This is the matter of Dawson versus Pearson. We're here today on the third party grandparents' objection to the referee recommended order in this matter. And Mr. Kajewski, I have read all of the motion or the objection, the responses, etc. So you don't have to cover all of it.
Thank you. However, I do think that the objection was raised by brother counsel. It's actually, I think.
Yeah, we're the ones that
Oh,
actually
that's right. I'm
objected.
sorry.
Oh, that's
I'm
right.
sorry. Yeah, you're right. I got it backwards. Go ahead, Mr. Kirchhoff.
Thank you. If you've read the objections, when I got the transcript, I had supplemental objections that were specific to the transcript because I was not present for the initial hearing. But what it comes down to is this is a grandparenting time request. And the standard under the statute is extremely high to grant grandparenting time when one of the parents does not want it. And while it's a preponderance of the evidence, they have to show that it's in that not granting it basically hurts the child. And at the hearing, the only thing that was ever put in that had anything to do with that was this supposed statement made by the 5-year-old grandchild when she saw her grandmother back in April. Ms. Dawson had an opportunity to testify and basically told the court she never ever said anything of that nature to her daughter, wouldn't involve the child in that in a dispute between her and her mother. So consequently, the only evidence that they ever could point out is supposedly this statement, which was totally denied on the record under oath by my client. That does not constitute a preponderance of an evidence showing that denying this parenting time is going to somehow harm the child. So I think the referee's decision needs to be reversed, Your Honor. It still is within the realm of the parent to determine who and when their child sees somebody. And, we're not going to get into what has happened between her and her mother. It doesn't particularly matter, but Ms. Dawson has made the decision that it is not in her child's best interest to have parenting time with a grandmother. And so we are asking that it be reversed.
All right. And you are entitled to an evidentiary hearing. But I guess the question is, was there evidence that was not presented, that was available, that was not presented at the referee hearing?
Well, I think there probably was, for the simple reason she represented herself. And we all know what happens when you represent yourself. That was her choice. She made a choice. She, quite frankly, shouldn't have done it. I think if we had an evidentiary hearing, there'd be a lot more evidence presented on her behalf because she would know how to present it because I would be there representing her.
Well, I don't think that's the basis to grant a do-over, essentially, because the court would be inclined to simply decide it based on the transcript unless there is new evidence that was not available at the time.
Well, we don't have a problem with deciding it on the transcript.
Okay.
As I previously said, she made her choice, unfortunately, back in September when she chose not to have an attorney there with her.
Okay.
But even on the transcript, I don't believe that anything substantial was presented on behalf of the grandmother.
All right. Mr. Kajewski, I have read your response.
Thank you, and I'll be very brief. And I have not issued response to Brother Counsel's supplement, which we just received essentially last weekend. So I'll just quickly address those issues here, if I may. So we completely agree with Brother Counsel that when it comes to MCL 722.27B, 4B, that is the standard, and it is a rebuttable presumption. We believe that when it came to the evidentiary hearing that was conducted by the referee, that the referee made affirmative findings that that particular presumption was successfully rebutted by a preponderance of the evidence. We have testimony from my client that the child has had a wonderful, almost everyday interaction or relationship with the grandmother. We even have, I believe it's on page 26 of the transcript, where when it comes to the mother of the child, she actually admits that, yes, there was this relationship where they were seeing each other almost every day because my client was providing childcare. But ultimately, we were able to show, and the referee was able to agree, that there would be substantial harm, psychological harm to the child if the child were not allowed to see the grandmother. Since the order was entered after the hearing, the grandparenting time has been going by just smoothly for the most part. A little bit of a dust up perhaps, I believe, on or about December 5th, but I think that's because of the holiday coming up and some school scheduling things that happen, but that's neither here nor there right now. But my client would be able to show you, not necessarily today, she can, but if we would have to at evidentiary hearing, that she is a fit parent and, well, I'm sorry, grandparent, and there's no risk to the child, but more so the standard of the child being harmed by not having her in her life absolutely is there. So we also heard from Brother Counsel too that there is no additional evidence specifically that could be pointed to today. And I believe that according to the court rules, that is a firm basis for this honorable court to deny a de novo hearing based upon even that alone. So we would be asking this court to uphold the referee's findings of fact, the recommendation, and the subsequent order that was entered.
All right. I will take this under advisement. I will, I'm granting the de novo hearing, but I will be doing it based on the transcript, based on essentially the stipulation that there'd be no appropriate brand new evidence that was not available at the time of the original hearing. And I will try to get something out as soon as possible. I do have several things under advisement at this moment, so it may be a little while. I just wanted to give you that heads up, but I will review all of the evidence and enter a decision.
Thank you very much.
All right, thank you. We're adjourned. Palazzola versus Palazzola, case number 24-05479-DM. Present in the virtual courtroom, we have both parties, as well as attorney Stephanie Korndike, representing the plaintiff, Mr. Palazzola. We're here on Ms. Palazzola's objection to the denial of an ex parte order, which I think procedurally is not quite accurate, but I will treat it as a motion to change custody, parenting time, and support, given that Ms. Palazzola is representing herself, and I believe her allegations are sufficient to give notice to Mr. Palazzola of what it is she's asking for. I have read your motion, and of course I read the ex parte motion previously. Is there anything else you'd like to say at this time, Ms. Palazzola?
I thought this was also in regards to the was this in regards to the ex parte motion for the no contact order?
You don't get to object to an ex parte denial.
Oh, okay.
So I am, like I said, I know you're representing yourself, so it's
Mhm.
a little messed up procedurally. I'm treating this as a motion to change.
Your Honor, if I may, maybe she's confused because we filed an ex parte
Okay.
that was granted.
Okay. All right. That could
So
be.
I think that
Okay.
she thinks that this is the objection to that, but I don't know if she met the time frame requirement.
Okay. All right. Well, yeah, I read it 3 times and I was still confused. So, as far as procedurally where we're at, because, well, for one thing, the order was not attached. All right. Ms. Korndike, I'm going to let you go first just so that I can get it clear in my mind where we are here.
Yes, Your Honor. So procedurally what happened is that we filed a ex parte motion to bar contact between the defendant's boyfriend and the minor child. We did file that due to, one, his criminal record, which included a child abuse conviction, and my client did have a PPO against that individual as well. So that was part of our allegations. Is we're not saying that Miss Palazola can't have parenting time. We just don't want her boyfriend to be at the home at the time due to that child abuse allegation. It is a conviction, unfortunately. So that is very concerning to my client. We filed that, then she filed her ex parte, which was denied. And so I don't believe necessarily, I agree that she can't then object to her own denial, but I do believe she is objecting to our original ex parte and maybe just messed up the titles or something like that.
And I see her nodding her head. And Ms. Palazola,
Okay.
is that what your intent was?
Exactly.
Okay. All
And
right.
I have it. Yeah, that's what that was for.
Okay. All right.
So,
go ahead,
Your
Ms.
Honor.
Grendark.
Yes. So, Your Honor, we're asking that if you are intending to consider lifting that provision, we definitely need an evidentiary hearing. There are significant concerns about the boyfriend. I don't think it would be appropriate to just lift it on a motion morning. I think more information is needed, especially in light of that conviction. And I know that, you know, the defendant is going to say, well, it was a misunderstanding and that's why, you know, it's on his record or something like that. But that's still a child abuse conviction on his record. And we're here dealing with a child. So also, if she is intending to try to change custody, I don't believe that she's met the burden under Vodvarka either.
All right. Thank you. Ms. Palazola, if you could just in very simple sentences tell me what you want me to do today.
Yes, the objection was to rescind or modify the no contact. That's what the objection was originally for. It was not an objection to my ex parte that
Okay.
was denied.
Okay.
I have submitted information regarding the allegations made by Mr. Palazola. In contrary to that, I'm confused as to where the changing the parenting time and custody is coming from. I'd never filed for that.
You checked it on your motion, but that's okay.
Oh,
It's all right. It's all right.
sorry.
Now that I think I have a good idea of where we are here. So what I will do, I mean, obviously there's some factual dispute here. I will refer this to the front of the court for investigation. But in the meantime, I will leave the no contact order in place until we get to the bottom of what's going on here.
Okay.
All right.
Thank you.
All right. And we will take care of that referral.
Okay.
And I will indicate that the parties are to split the fee.
Your Honor, would you like me to draft a order just stating that the no contact would be left in place for now?
No, we can take care of that. We'll just put that right in our, I mean, it's in place until it's lifted. So
okay,
I don't think we need a separate one.
Okay, perfect.
All right. All right, we are adjourned.
I had a question.
Okay, go ahead.
And I thought his attorney was going to bring this up. I have not seen Kian since December 9th.
Well, the current parenting time order is still in place. It's
Your
just that
Honor,
he can't be around.
that's the issue. Is she's not trying to set up a third party. We've tried. As long as there's a third party to do the pickups, we're more than happy. But he's not going to willingly violate a PPO.
Excuse me. I was notified by the PPO office when I picked up the PPO that parenting time orders and custody orders override the PPOs. And I offered to meet him at the police station and now all of a sudden his mom is not a willing party. It's making everything difficult. And like I stated, I have not seen Kian or spoke to him since December 9th.
Well, there's no reason not to have video and phone calls.
Okay.
Absolutely no reason.
Your Honor, can I?
You have an attorney. No.
Yep.
So,
I will instruct him, Your Honor.
yes,
Your Honor, if I may, this is Attorney Smulders. I was in another case. I do have information just regarding that particular subject. He
All right.
has tried with video and phone calls. So he has tried. He sent me a call log proof of that. So I just want to interject with that so the court doesn't necessarily frown upon that issue.
okay.
I object to that. Because I had one phone call with Kean on Christmas Eve.
Well,
And
I,
ever since
Ms.
then, he's
Palazzolo, the
refused.
front of the court has a process in place for violations of parenting time.
Mhm.
And so I would suggest that you pursue that route. That's not something I'm going to address today.
Okay.
But my other information is, or my other directive to the parties is that parenting time should be occurring, but Ms. Palazzolo, you're going to have to figure out some way to do that without involving the person against whom the no contact order is.
That's not what this is about, Judge. This is about a PPO that I filed against Mr. Palazzolo. Ever since he was served that PPO, he's held it against me.
Again, there are ways to get around this. The front of the court can help. Reach out to them. All right. We're adjourned.